When does the 2-year statute of limitations not apply to Connecticut car accident cases under Section 52584? Most injury cases in Connecticut have a 2-year filing deadline, but crucial exceptions can change the timeline. The standard rule under Connecticut General Statutes Section 52584 gives you 2 years from the date of injury or discovery to bring a personal injury lawsuit and includes a 3-year statute of repose that bars cases more than 3 years after the negligent act. Understanding when the clock starts and stops is essential because missing the deadline can eliminate your legal rights and bargaining power. A statute of limitations is a law that sets a deadline for filing a lawsuit, while a statute of repose sets an absolute outer limit regardless of when you discovered the harm. The 2-year statute does not always apply because Connecticut law recognizes several exceptions. Under the discovery rule, the 2-year clock begins when you discover or should have discovered your injury, protecting people whose injuries are not immediately apparent. For example, hidden internal injuries, soft tissue damage, neurological symptoms and delayed onset pain may qualify if you could not have reasonably detected them earlier. The discovery rule does not extend the 3-year statute of repose and still requires that you exercise reasonable care in monitoring your health. Government claims create even shorter deadlines because claims against state or municipal agencies involve special notice requirements. You generally must present state claims to the Office of the Claims Commissioner within 1 year and file suit within 1 year after receiving permission. Claims against cities or towns may require written notice within 6 months, and defective highway cases impose a 90-day notice period. Failing to meet these notice periods can bar your claim even if you later file within 2 years. Fraudulent concealment tolls, pauses, the limitations period when a defendant intentionally hides facts that would alert you to your claim. To use this exception, you must prove that the defendant knew of their wrongdoing, intentionally concealed it, and specifically aimed to delay your lawsuit. Examples include a driver lying to police about what caused the crash or an insurer withholding evidence of intoxication. The concealment must be directed at preventing you from discovering your claim within the statutory period. If the person responsible for your injury leaves Connecticut before you can file, the statute of limitations is paused for the time they are outside the state, up to a maximum of 7 years. This tolling applies only when the defendant's absence prevents you from serving them with legal papers, and courts will examine whether alternative service was possible. Wrongful death cases have different timing rules. They must be filed within 2 years from the date of death, not the date of the accident, and are subject to a 5-year absolute limit from the date of the negligent act. This means that if someone is injured in a crash and dies 4 years later, the wrongful death claim must still be filed within 5 years of the accident. Product liability claims involving defective vehicles or parts have a 3-year statute of limitations and a 10-year statute of repose under Con. General Stat. Section 52-577A. These claims allow you to pursue manufacturers for defects like faulty airbags, brakes, tires, seatbelts or steering mechanisms. Exceptions to the 10-year repose period may apply if the injury occurred during the product's useful safe life, if an express warranty exceeds 10 years, or if the manufacturer engaged in intentional misrepresentation, fraud or concealment. The continuing course of conduct doctrine is a rarely used exception that may extend the statute when a defendant's wrongful actions and duty of care continue over time, but Connecticut courts apply it narrowly and it does not override the 3-year repose period. Once you discover both the injury and its cause, the doctrine generally does not apply unless there is ongoing breach of duty. Missing the statute of limitations means losing the right to file a lawsuit, recover compensation or negotiate with insurers, and courts enforce these deadlines strictly. Insurance companies may delay negotiations hoping you miss the deadline, so timely legal action is crucial. A skilled lawyer can help identify applicable exceptions, gather evidence and file within the correct timeframe. If you are unsure whether the 2-year deadline applies to your case, speak with an attorney promptly. At DeFronzo Petroskey, PC, our lawyers fight for injured drivers and passengers throughout Connecticut and track every critical deadline. We handle personal injury and car accident cases from investigation through negotiation and litigation, ensuring your claim is filed on time. Our law firm is based at 255 Bank Street No. 2B, Waterbury, Connecticut, 06702, United States. Call DeFronzo and Petroskey, PC at 203-756-7408 to schedule a free consultation with an attorney who understands Connecticut statutes and will work tirelessly to protect your right to compensation.